Good morning, everyone. Apologies for being just a few minutes late, a minor technical glitch on my end, but everything is good now. And this actually works out better for the timing, so thank you so much for hanging in there. Welcome to day 3 of the 2021 virtual CSGS conference. Wow, what a conference. It's been wonderful. It's been provocative, some amazing speakers, some great opportunities to catch up with colleagues. Really appreciate you being here. My name is Jack Duraki. I'm president of CSGS this year, and I'm just thrilled to be opening day 3 and our final day of the conference. Once again, let me thank our sponsors, ETS, ProQuest, as well as DoctoralNet. Thank you so much for hanging in there with us during such a tough year. We really appreciate your support of graduate education. ProQuest will be making a brief presentation later today during our awards ceremony. So please join us there as it precedes the student and faculty awards. Another word of thanks to our amazing tech crew. Thank you so much, Dr. Julie Goodliff, Constania Charbonnet, and Desi Hacker. It's just been a wonderful job and can't be more thankful. Couple notes. The survey for the conference will be distributed via email to all registrants, all attendees. So be on the lookout later today or tomorrow for that. Please let us know how the conference went, how the Hopin platform worked for you, all that good stuff. We will definitely use it to improve our fora going forward, as well as future conferences. Also, on the CSGS webpage, you will find the slate of nominees, as well as the agenda for today's business meeting. You'll also find the minutes from last year's business meeting. Please join us later today. That'll be the last part of our conference. So, how to recap day 2? What a wonderful day. We got it kicked off with some really invigorating brown bag lunch conversations that were just so well attended. We had a wonderful session on the positive changes that we've been able to make as a result of the pandemic, and that's such an important thing to do, to take stock of the many silver linings that we can take from our work this past year. We also had a great session on the implications of all the grading changes we've made and what those might mean on future applications down the road. And then, of course, thank you so much, Mary Farmer-Kaiser and Michael Cunningham, for the wonderful New Dean's Workshop. So it's clear that we've gotten very used to the technology. Really appreciate that. Everybody's worked hard, and it's just had a wonderful, engaging conference thus far. Day 3 promises to be just as awesome, right? Just as great. How do you top the first 2 days? Well, you got to bring in the closer, right? You got to bring in the one to make it finally pop. And of course, we will do that with one of our favorites. We're so pleased to welcome Mackenzie Wilfong as our 3rd plenary speaker today at 9 o'clock. She serves as general counsel for the Tulsa Community College, and always is a wonderful plenary session and very provocative. So look forward to that. Following Mackenzie's talk, we will have our 3MT finals, which is always a highlight. It's always a wonderful way to conclude our conference as we see the amazing work of our graduate students. So please join us for those finals. And then finally, we will have our awards ceremony and business meeting. Again, as mentioned previously, please plan on joining us for that. It's always wonderful to hear from the thesis winners as well as the faculty. And the business meeting is important. We will be voting on our next slate of officers on the executive committee, as well as an important bylaw amendment. As I mentioned in my opening day remarks, a communications committee worked this year during the pandemic to think about ways that CSGS can communicate with our members more effectively. And this bylaw change in our business meeting, where we will vote on that, is just one step, and you'll hear more about that as we go forward. But thank you so much for being here. Once again, let me remind you on the left side of your screen, right, this is the main stage. This is where Mackenzie's plenary presentation will commence in just a few minutes. And then underneath that is the sessions tab, where the 3MT finals will be, as well as the award ceremony and business meeting. Those meetings go live 5 minutes before the start. So just be in that sessions tab and you'll be able to join us. We will be recording those sessions, so only 9 cameras on at a time. This is particularly for the award ceremony and the business meeting. Again, I do encourage you to join us for the business meeting. I know many of you may not be able to attend, but we do have some important items to go over. And of course, the final great moment when we will be handing over the gavel to Dr. Karen Coates to begin her illustrious reign as CSGS president for the next year. So it is 8:55 now. Welcome to day 3. It's going to be a wonderful, exciting day. I'm going to go dark for just a few minutes. This stage will go dark for just a few minutes, and then we'll be back right at 9 o'clock to introduce Mackenzie and begin what will be a wonderful final day of the 2021 CSGS conference. Thanks so much for being here. Good morning, everyone. My name is Jack Duraki, president of CSGS, and it is my pleasure to welcome you to today's third plenary, or rather the third plenary of our conference on today, Friday, our last day. It is my pleasure to introduce Mackenzie Wilfong, who has done many of those for CSGS over the last few years, and it's just such a privilege to have her here. Mackenzie, welcome. It's great to see you.
Thank you. Great to see you all. You too. And hi, everybody.
That's right. And I think, and both of us are like, okay, his mic worked. Yes. All right. So
yes.
That's good. Very good. Let me just give a word of introduction for Mackenzie before turning it over to her. Mackenzie earned her Bachelor of Arts from the University of Oklahoma, where she graduated Phi Beta Kappa. She received her Juris Doctorate degree from Southern Methodist University's Dedman School of Law. Following law school, Mackenzie practiced litigation at a national law firm in Kansas City, where she specialized in education and employment law, practicing in both Kansas and Missouri. After leaving private practice, she joined the United States Department of Education, Office for Civil Rights, as a federal enforcement attorney investigating allegations of harassment and discrimination in a 5-state region during both the late Bush and early Obama administrations. Most recently, for 9 years, Mackenzie worked for Oklahoma State University and its board in several roles, including Associate General Counsel, representing 9 colleges and universities across Oklahoma. Mackenzie has served as an adjunct professor teaching higher education law and as a guest lecturer in the Oklahoma Career and Technology sector, teaching continuing education in Oklahoma medical marijuana, employment law, and COVID-19 related Federal CARES Act funding. Mackenzie also co-authored a chapter on the First Amendment in higher education for the recently published book, Student Conduct Practice, the Complete Guide for Student Affairs Professionals. And currently, Mackenzie is the general counsel for Tulsa Community College, where she serves on the executive team and provides legal counsel for the college's 4 campuses, serving 25,000 students in Tulsa County. Mackenzie, welcome. It is just so great to have you here. I'm going to go ahead and turn off my camera and turn the show over to you.
Okay, thank you. Well, hey, y'all. I hope all is going well with you. We have some really exciting and fun legal topics today, and I am so excited. It's so much warmer today than it was last week. And so I'm going to share my screen, and then we will get started. All right. So first off, we're going to talk about a number of different topics, and I'm so excited to share these topics with you all today. First, we're going to start with some federal leadership changes and how those federal leadership changes will lead us to changes in policies and priorities for the federal government. And then we're going to move on to HERF changes or CARES or stimulus money. It's known by many names at this point. But talk about the COVID stimulus packages. So far, we have 2, and perhaps by the end of next week, we will have a 3rd. And so we'll talk about the differences in those, and particularly the monetary impacts that those have had on our institutions, and some interesting data coming out of that for our researchers. Then 3rd, we'll transition to international matters and specifically talk about a plethora of visa changes and focus a little bit on some DACA changes that we're seeing in the current administration. And then conclude with some trend observations. Not only are we going to see some fascinating First Amendment precedent potentially coming out of both the Supreme Court and some of our courts of appeal, and then conclude with a riveting case out of Kansas regarding lab data fabrication. And so anyone that is looking at revising or reviewing their academic integrity policies wants to hang out until the end to talk about that case some more. And then we'll open it up for questions that individuals may have, and then those will be read to me, and I will try my best as always. And so turning to leadership changes at the federal level. So I wanted to share with you three individuals who I think are going to have a significant impact, not only because of their roles within the new administration, but also because of some of their previous experience, particularly the Secretary of Labor in Boston, and kind of give you an idea of who will be running both the Department of Education Office for Civil Rights, and the Department of Labor. So starting off with Dr. Miguel Cardona, we anticipate he may be confirmed by the Senate as soon as today. And so it seems we seem pretty confident that Dr. Cardona will be our Secretary of Education under the Biden administration. And so I want to talk to you a little bit about who he is. And when I saw this picture of him, it was so delightful because if you notice the book that he's holding about building a trauma-informed restorative school, most things about Dr. Cardona seem very purposeful. And I think this is also very purpose-driven in reminding us that he understands really trauma-informed techniques in interacting with our students, which is perhaps a wholesale change with what we've seen previously. But President Biden nominated Dr. Cardona, and he is the head of Connecticut's public schools to be a Secretary of Education. And when he nominated him, he made a very interesting comment. President Biden said he's a lifelong champion of public education. And Dr. Cardona became the top education official in Connecticut in 2019, so hasn't been in that position long. But he was previously an assistant superintendent in the school district in Meriden, Connecticut, which serves about 9,000 students, so not an overly large district. But what's interesting is it's the district that he grew up in and went to school in, and it's also where he started his career in education as an elementary school teacher, specifically teaching the fourth grade. He's also been a principal as well. And so one of the things that I think is interesting about Dr. Cardona is he's taken some pretty innovative approaches to statewide administration. And in June of 2020, really during the heart of the COVID crisis, he talked about needing to, quote, fix the digital divide, and that being a major focus of his work in Connecticut for the COVID-19 pandemic. And it appears that Connecticut was the first state in the country to provide all public school students in the K-12 setting with universal access to learning devices. So all public school students receiving both laptops and high-speed internet so they could log on during the pandemic, which is pretty significant, and I think speaks volumes about inclusion, accessibility, and understanding the challenges of our student populations, even in higher education. And which leads me to our next nominee, Suzanne Goldberg. And right now, Suzanne Goldberg is in an acting capacity. And so the U.S. Department of Education Office for Civil Rights, although it is a sub-office within the Department of Education, it is incredibly influential for those of us in higher education, and particularly in the legal field, because that office, my former employer, the Office for Civil Rights, they regulate all issues regarding Title IX, so both athletics compliant, harassment, sexual assault, sexual misconduct, as well as Title VI, which regulates harassment and discrimination based upon race, color, national origin, and also Section 504 of the Rehabilitation Act, and some with the Americans with Disabilities Act in the educational setting. So for your student disability services, anyone who has a complaint about those areas, they file it with the Office for Civil Rights. So who runs that office, and it's typically an attorney, is a very important pick. And for many of us that work in this legal area, some might say more influential on the day-to-day inner workings of our colleges and universities, maybe even than the Secretary of Education. And so Suzanne Goldberg is a fascinating choice for this role. So a little bit about her. Ms. Goldberg previously served as the inaugural executive vice president for University Life at Columbia, which for those of us not at Columbia, that is somewhat similar to a vice president of student affairs that we would have on our campuses. Um, she's also the founding director of the Columbia Law School Sexuality and Gender Law Clinic, co-director of the Center for Gender and Sexuality Law. Before she came to Columbia, she worked for and was faculty at Rutgers Newark Law School. And before that, she started her legal career at Lambda Legal, working on a variety of progressive legal reforms and cases and regulations for the LGBTQIA community. And Lambda Legal is absolutely, hands down, the premier law firm and advocacy group that does a lot of legal work for the LGBTQIA community and initiatives to support the community. And so we haven't really seen a progressive individual in this role at OCR since Catherine Lehman. Catherine Lehman was the appointee for this role during the Obama administration, but there's some really interesting differences that I think we'll see between Catherine Lehman, who was a noted litigator, and Suzanne Goldberg, who was a practitioner and then a faculty and an educator, and very involved in higher education administration as well. And we have not seen that in this role at OCR for many decades. And so I think it is an exciting time for the Department of Education Office for Civil Rights. When I talk to my colleagues who still work there, I think that they're very excited to have a practitioner in higher education, a former administrator, and a knowledgeable legal mind to come in and lead that part of the organization. It's pretty exciting. Marty Walsh. So many may wonder, why are we talking about the Secretary of Labor? So the Secretary of Labor will have a lot of control over really how our employment law matriculates, specifically with the Equal Employment Opportunity Commission and the Office for Federal Contract Compliance Programs and others sub-agencies and offices under the Department of Labor. So Marty Walsh is a second-term mayor of Boston, and he has, for those of us that work in unionized environments, he has extensive ties to labor unions. Before being elected Boston's mayor in 2013, he served as a state rep in Massachusetts for 17 years and led the Boston Building Trades Council, which represents union construction workers. So why I'm personally interested in Marty Walsh is a very interesting program that started in Boston in 2016, and it's called Boston's Tuition-Free Community College Plan. And what it does is it covers 3 years of tuition and mandatory fees for all low-income eligible students after you apply Pell Grants. And currently there are 6 community colleges who participate in this, including Bunker Hill, Mass Bay, and Roxbury in this program in Boston. And what I think is interesting about this, we've seen programs similar to this in Tennessee. We actually have one in Tulsa called Tulsa Achieves, where we do something very similar. But what's interesting about this program is instead of being led really at the college or the institutional level, this is led and funded wholly through the mayor's office of workforce development in combination with an interesting public charity called Neighborhood Jobs Trust, which is a public charity that collects fees from commercial developers in the city and then redistributes those fees to low-income students to assure them their first 3 years of college. And so several community colleges and advocates have noted that although Marty Walsh is over and will be nominated as the Secretary of Labor, that he has strong ties to higher education because of this program and realize the value in higher education, for which that's incredibly exciting. We have not seen this kind of slate of individuals really involved with valuing higher education at labor, education, and then also at OCR. And I also think with so much discussion regarding tuition-free community college and how we're going to make college and universities more affordable, Walsh is an interesting choice. So there's a lot of words here. We're going to walk through them. Not only are we going to see a different kind of leadership, I think, within our federal regulatory agencies, we're also going to see some pretty significant policy shifts. But these policy shifts are not going to come easy. And I want to take a minute to explain why, although there may be different policy priorities, particularly in the Title IX related areas, these are not going to happen overnight. And so a little bit about, how federal regulations and executive orders work for a minute. So when a federal agency engages in what's called a notice and comment rulemaking, like whenever they publish it in the Federal Register and they ask all of us, to comment and to read it, and they post that notice, and then eventually that's called a notice of proposed rulemaking, and then eventually we hear those comments told back to us in a document right before we see the final regulations. And we may see some changes between the proposed regulations and the final regulations. And as we all know, that takes a lot of time. If the federal government has gone through this extensive effort through a federal agency to promulgate federal regulations, then you'll have to do the same thing to amend those regulations. You will have to go through the same notice and comment period to amend those regulations. And that does not happen overnight. That does not happen in 6 months, right? That takes quite a while to tee up that process. On the other hand, regarding presidential executive orders, once a presidential executive order is issued, it remains in force until it is either revoked, adjudicated unlawful, or expires on its term. And at any time, the president who issued the executive order or an individual who is currently president can revoke, modify, or make an exemption to any executive order, whether it was made by them or it was made by their predecessor. And that can simply be done through the executive order process. And so the bottom line is how rules are put in place, be them regulations or a letter of sub-regulatory guidance, similar to Dear Colleague letters that we see often, or an executive order. How it's put in place dictates how it can be modified or revoked. And so I would anticipate we're going to see a lot of movement in the Title IX area. And so just not to harken back to the summer too much, I don't know if it's a summer we all want to remember with exacting specificity, but in the early summer, the Department of Education issued 2,000 pages of new Title IX regulations that took over 3 years to draft, and they provided institutions of higher education right at 100 days to implement. And so they were issued in mid-May with the intention of those being fully implemented by colleges and universities beginning at the beginning of the fall semester. And so please know it was a summer stressor, and for your Title IX coordinators, they did yeoman's work because there were, I would say, probably no Title IX policies and procedures at a college or university level that weren't significantly changed over that summer timeframe. And so what we know about the Biden administration is they have specifically said during the campaign and even early on in his administration that those Title IX regulations, while they may not be revoked, are going to be significantly modified, and we're waiting to see what that looks like. What we do know is that one of the first executive orders signed by President Biden affirms that both gender identity and sexual orientation are protected classes under the federal sexual discrimination laws. And that is really to help align our federal discrimination laws with the recent Supreme Court case that came out in June, Bostock versus Clayton County. Um, However, even whenever we are looking at the Equality Act that's currently meandering through Congress, that affects Title VII and Title VI. It is silent as to its relevance to Title IX. And so there is still going to be this outstanding issue of interpretation regarding Title IX as it applies to sports participation and transgender status. And that will probably require some significant guidance from the Department of Ed and a regulatory change. And that's why really the nomination and the work of Suzanne Goldberg is a critical area to review as we look to these Title IX related changes. In addition, as you may recall, under the Obama administration, there was some pretty influential councils regarding gender-based issues that were run by Valerie Jarrett, who was a close confidant and ally of the Obamas. And during the Trump administration, we saw those councils and committees that really were dealing with gender issues were no longer utilized. One of the first acts by the Biden administration was to reconstitute the Gender Policy Council, which he says will play a critical role in pushing forward Biden's agenda. And I think it's not just saying it, because he has placed as co-chairs of this effort two notable individuals, Ms. Reynosa, who served as ambassador to Uruguay, Jennifer Klein, who served as senior advisor to Hillary Clinton when she was First Lady. And so on Title IX and gender-related policy issues, I think that we're going to see a lot of action, not only coming out of the Gender Policy Council, similar to what we saw in the Obama administration. We're also going to see some significant changes either in the Title IX regulations or its interpretation. And eventually someone's going to need to clarify through an amendment to the Equality Act or additional guidance from Department of Ed, squaring up issues of transgender status with Title IX. Moving on to executive orders. So most of the Title IX issues, because we have 2,000 pages of regulations, that's going to take a while. Juxtapose that to these executive orders, which were rapidly implemented in the final 6 months of the Trump administration and just have rapidly been revoked or are being addressed in the Biden administration. The most notable that we have seen and discussed really in the higher education community has been Executive Order 13950, which you will recall prohibited employee diversity training for federal contractors, of which almost all research institutions are federal contractors. It also really put the spotlight on discussions regarding critical race theory and whether or not those discussions could be included in our diversity training. That was one of the very first executive orders that Biden revoked. And so and then further clarifying this, the Office of Federal Contract Compliance Programs put out a plethora of notices saying the hotline and the email hotline that we set up for people to let us know if this diversity training was occurring is no longer being monitored. And the guidance and FAQs that we sent out, those are now revoked as well. And so not only was there a revocation of the executive order, but there was really immediate action, same day, by the regulatory agency within the Department of Labor that dealt with this executive order, and they revoked all of their guidance regarding it. I know that I've talked to a number of colleagues, and on occasion, this feels like, regulatory whiplash, because we're walking down one road, and then, not even 2 or 3 months later, we're pivoting to something else. And I think that we may feel that way, particularly in the federal regulatory area for a while, because there were a lot of executive orders and a lot of late federal actions that we anticipate the Biden administration to address. One that is interesting, that has not been revoked, and is still outstanding, which is a little bit surprising to me, is Executive Order 13864, and it deals with First Amendment litigation. I think many organizations are requesting, a review of this and perhaps a revocation. And so I want to talk a little bit about this executive order. It flies under the radar a little bit, partially because it wasn't picked up by the media as much as 13950. But the final rule became effective on November the 23rd. So this is an executive order that precipitated regulations, and so it may take a little bit longer to address. And the issue here is for attorneys that represent colleges and universities, if we have a judgment against us after a trial by a state or federal court where they find us not in compliance with the First Amendment, if we're a public institution, or if we're a private institution and we've incorporated concepts of the First Amendment into, say, our faculty handbook or our employee handbook, then we have to notify the federal government of that within 45 days of that final judgment. And then they can start a revocation of federal funds process. That was startling to many of us, and really would give us pause whenever we look at adjudicating First Amendment claims. The final rule does not require that we tell the Department of Education if we have a settlement or a mediated agreement. So one can imagine that perhaps it would encourage individuals to either settle or have that kind of mediated agreement. Biden has not revoked this executive order yet. Also buried within this executive order was a quote that I want to share with you all, and it's not here on the screen. And it says this, so I'm going to read it. The First Amendment right of free expression means that public officials may not discriminate against students or employees based on their viewpoints. Got it? For example, public institutions cannot charge groups excessive security costs simply because these groups and their speakers might offend a hostile mob, period. That one sentence within the executive order and then incorporated into this final rule is a little bit concerning, because for those of us that work in this area, and now COVID has changed a lot of things, and so we're seeing perhaps less groups and speakers on our campuses. But eventually, when that returns, and if we still have this executive order, it will be challenging for many of us, because we know that it costs a lot of money to keep our campuses safe. And we now know that that money cannot be passed on to others. And just to give you some ballpark figures, in 2017, the Virginia State Police, regarding addressing the horrible circumstance, the quote, Unite the Right rally that occurred in Charlottesville, the Virginia State Police alone spent $916,000 responding to that. Interestingly, due to an open records request by a colleague, we were able to learn that in 2018, on the anniversary of that, the state police alone spent $3.9 million on operating during preparations for the anniversary weekend of that. These are incredibly expensive rallies to ensure that you have a safe community. And we have seen this really even going back to 2017, 2018 with the Richard Spencer's trip to the University of Florida, which cost upwards of $600,000 in security. University officials said at the time in some news reports. I suspect it might even be incredibly more. With this executive order still sitting there, those are monies that we cannot pass on either to the group who requests the speaker or to the speaker themselves. And so hopefully we see some revisions of this and an acknowledgement that keeping our campuses safe is important. What else is on the federal policy horizon? Well, there are some real discussions in the administration about talking about doubling Pell. And for those of you all that really work deeply in financial aid, you will know that there's also discussions about broadening the estimated family contribution. Um, so although we have heard about canceling education debt, I think that there is becoming less and less an interest in seeing that cancellation of education debt, rather doing some of these other areas like doubling Pell, broadening estimated family contribution, meaning individuals would be more eligible for Pell because they would not be as hampered because their families perhaps are higher wage earners. And then finally, to conclude, um, in the churn of the pandemic, many of us were caught and not unaware, but perhaps not fully prepared to implement some of the pretty significant changes that were embedded in the very lengthy distance education regulations. The Department of Education keeps reminding us about these. They again sent out a notice on January 19th reminding us. But there are two areas of distance education regulations that I want to bring to your attention because they are truly like nuggets in the rough buried in these rules, and they have really nothing to do with distance education per se as we think about it. And so I think many people kind of glossed over these areas thinking, well, that doesn't apply because we're not engaging in distance education in the same way, thinking that the title of the regulations actually governed what was in them. And so there are two areas that really impact graduate education that you want to be aware of. The first are the professional licensing notification requirements. It became effective in August of 2020, and I think that's probably why it wasn't discussed extensively other than areas of financial aid, because it is part of the mandatory disclosures that are required for financial aid. In this, colleges and universities are required to determine, quote, programs. Now, it does not matter if they're distance programs or if they're in-person learning programs. So it truly is a misnomer that this was in distance education regulations. Okay, so you have to determine programs that are, quote, designed to meet the educational requirements for specific professional licensure or certification that's required for employment in that occupation, or if you're advertising it like that. So let me break it down for you. If you have a nursing program, and this frequently comes up with all allied health programs, counseling programs, psychology programs, professional engineering, where your program, your course of study is going to lead to an individual who's going to need to get a license in order to practice that discipline in the state. If the student is applying from out of state and you see that on their application, that they have an out of state address, then the college or the university has to determine whether or not the program that you have at your institution will meet the professional licensing requirement of that state where the student is applying from, even if they're coming to your state to do it and it's in person. And then you have to provide that student notice of one of three things. Either, yes, it meets the requirements. No, it doesn't meet the requirements, or we don't know. And then you have to create a website that houses all of this information. And this is just one of the myriad of areas that professional licensure was impacted by these rules. And so I provide the Code of Federal Regulations citation, and we'll make this available in PDF for you all. So in case you want to go and talk to your other folks on your campuses, it has been my impression in talking with colleagues that this really went relatively under the radar. And whenever you have your financial aid reviews, this will be part of that standard review process to ensure that you are making those correct disclosures. It's now one of the mandatory disclosures for financial aid. Also buried in these distance education rules is an issue of transfer credits. Now, I'm not kidding. It starts on in the regulations on page 58,580, like no joke. It's that buried. And there is an issue about transfer credit. So your college or university can no longer make the sole distinction about whether or not you're going to accept transfer credits based upon whether it was from a regionally accredited institution, think like HLC and SACS, versus a nationally accredited institution, think like many institutions that accredit for profit. Many institutions take transfer credits from regionally and on their face do not accept transfer credits from nationally accredited institutions, and that is the distinction of where they will start the discussions of transfer credit. Your institution may need to look to change that transfer credit policy because we are no longer now allowed through these regulations to make the distinction between regionally versus nationally accredited. And for many of us, that's really what we had relied upon previously. So it has been a time with federal regulation changes. And so I tried to wait a little bit into the presentation before I started discussing COVID-related, pandemic-related concerns, but I suppose it was inevitable. And so next up, I want to talk a little bit about the numerous rounds of stimulus packages that we have seen coming from the federal government, and with the hopes of demystifying really where we are in the process, what has been received and distributed, what is yet to be received, etc. And to maybe provide some insight into the very complex nature of this funding. It's been truly an extraordinary time in receiving these funds and then determining their appropriate use. And so we're going to go back in time a little bit, starting in March of 2020. In March of 2020, we started to see the federal government talk about the first stimulus package. And included in that March stimulus package, are a bunch of funds. But I want to specifically talk about the $14 billion that, with a B, that was directly related to institutions of higher education. We started to see that money coming into our institutions, and the conduit for that money, which, the details matter. So the technical conduit for that money is what's called a G5 account. It is a holding account within your financial aid office, the same way that the federal government funnels federal financial aid through to your institutions. It's the identical process that was used to funnel the CARES Round 1 mid-April funding into the institution. When we saw that first round, we sat through a number of webinars with the Department of Education, at least 4 FAQs with progressive amounts of information, because there was such a rush to get that money to institutions that the Department of Education was really, I think struggling is not an inappropriate term, to provide guidance about the parameters of use. And so at the bottom of the screen, the Department of Education has a website where they have archived all of the guidance provided for CARES 1 money. That's going to be incredibly important because the guidance really evolved over time. And so for individuals who made decisions early in April, what they learned after the end of the fiscal year in July is that perhaps those decisions were not compatible with the current guidance. And so there was a struggle to make sure institutions were using this money appropriately. So what we know is that 50% of the money provided individually to institutions. And so there's a long spreadsheet on Department of Education website where you can see the money that was allocated to every institution of higher education in the US based on state. And so when we received that money, 50% of the money was required to be directly provided to students. and 50% could be used and retained at the institution, although the institution could allocate some of their institutional funds to students. They were not required to do so. For the 50% that went directly to students, the Department of Education did not require a specific rubric for how that money would be allocated. So, pick 10 institutions and you saw 10 different ways. And so for some, they used a tiered approach based upon estimated family contribution and financial aid. For those that were had zero estimated family contribution, meaning their family could contribute nothing based upon the calculation by the federal government for financial aid purposes, they were provided perhaps with more funds than others. Other schools took an across-the-board measure, and every individual who was in school at the time received X amount. Others had a very individualized approach that included an application process. And so there are a wide range of ways where students were provided this funds. One of the more controversial portions of CARES 1 is because the federal government did not allow for this money to be distributed to international students or DACA students. And so there were a number of parameters placed upon those funds. The 50% institutional funds have its own set of FAQs about what you could use it over. Many institutions use it to offset housing losses, to offset refunds of student fees, for testing actually for COVID, or for reimbursement for PPE that they had been buying. But the allowable expenses were broader than just this. But when we looked at a couple of hundred institutions, these were the typical things we're seeing. Well, if you're interested in what your institution did, there's two places you can look to kind of get some insight into this. One, there was mandatory quarterly reporting required on a standard form that Department of Education provided halfway through. And that was required to be placed on an institutional website that was wholly unique just for CARES funding. And in addition, each institution that received funds has to file a mandatory annual report via Department of Education portal, which will be open records requestable and reviewable by outside researchers, which would be fascinating. The deadline originally was the end of January because what was asked in the annual report was so much more broad than what was in the quarterly reporting. Department of Education recognized that people were struggling to get the data in. And so they extended that deadline till the end of February. And so now institutions have to the end of February. After that, all institutions have to have their information in the portal. And then we really will have the ability to have a broad look to see how institutions allocated the funds. And there's even retention data in there to see, to help retain students. One interesting point is no 1098-T was required for the student distributions. And then there were governors who were allocated funds separate from the $14 billion, many of which provided some of that money to higher ed, some did not. Most waited until the end of December to make that decision whether or not to allocate to higher education. Round two. So what a difference a few months makes. The Department of Education made some significantly different decisions with the second round of stimulus money. The second round of stimulus money, which people have called CARES 2. Technically speaking, it is a different federal law. The acronym for the federal law is HERF, and so you'll hear other people call it HERF 2. It's all the same pot. And it passed Congress in December. And instead of it being a $14 billion, it was $21.2 billion. And it was allocated again directly to institutions of higher education. From what we are hearing from colleagues across the country is that hit their G5 accounts, similar to round one, only a few weeks ago, 2 to 3 weeks ago. Some saw it about a month ago, but that was unique. The institutions are required to spend the same dollar amount that they spent on students in round one and round two. So it is not the same 50% that must go to students. Rather, it's the same dollar amount that must go to students. Again, institutions can use their institutional funds to supplement that to students. Many institutions received more institutional funds than before, and due in part because the pie was bigger, 14 to 21 billion, but also because the equations were modified from the equation Department of Education used to provide this money was modified from full-time equivalent to headcount. And they also removed some for-profits from being able to benefit. And what was really great to see is they are now allowing institutional funds to be used to recapture lost revenue that was not allowed in CARES 1. And you can use it for payroll. And if you had any remaining CARES 1 money that had not been previously encumbered, because these were so close in time, they are allowing these new rules for recapture of lost revenue and payroll to also apply to unused CARES 1 money. As recently as 2 weeks ago, we became aware that this is going to require a 1098-T for students, which for bursars will be pretty significant and may, have a lot of questions for students regarding that. Perf 3, round 3. Well, we're getting there. We anticipate that the $1.9 trillion package will pass the House as early as today. It will go into budget reconciliation in the Senate, perhaps late this week or early next week. And we may see, in the budget reconciliation process, which does not require more than a simple majority, if we see the revocation of the $15 minimum wage, that it could go through the Senate relatively quickly. What is currently written in for higher education, right? CARES 1 was $14 billion. CARES 2 is $21.2 billion. HERF 3 is anticipated to be $40 billion. And as currently written, it's going to allow us to, in that section for student aid, include undocumented students and international students. And it also has some very specific provisions. For those of us that are state institutions, this is imperative that we understand that state institutions that receive this money, states are not allowed to spend any less of a proportion of their budget on higher education than they did on the average of 17, 18, 19. This is supplemental funding. This does not supplant state funding. The Education Secretary could excuse this if need be. However, a specific request will have to be made by the state if they anticipate cutting state funds and their institutions are going to receive HERF 3 money. So we wait for this money, and we may see, we'll see it as soon as perhaps the end of March or early April. There is a distinct chance that it does occur this semester. So that is where we are with HERF and CARES funds. And now I would like to move to the international concerns that we're seeing. President Trump, in the final days of his administration, issued a number of executive orders impacting individuals who are visa status holders. President Biden revoked Executive Order 13768 which was from early January, which deployed agents to the interior of the U.S. to help remove undocumented individuals, which caused our DACA students a significant amount of concern. That executive order has been revoked. And in addition, President Biden has proposed some immigration legislation, the U.S. Citizenship Act, which would provide both a path to legal status and residency status eventually for DACA recipients. As we recall, right, DACA makes it possible for our undocumented immigrants who arrived in the U.S. as children under the age of 16 to obtain deferred deportation, work permits, and other things. We know from the data we have about 200,000 DACA recipients who are currently enrolled in colleges and universities this year. And so we have a lot of students who are waiting to see what kind of DACA reform we may see within the Biden administration. And his proposed legislation would be a path to permanent residency. In addition, in the last 3 weeks, I do wait for this presentation and revise it. I was revising it again last night because so many things really even have changed over the last few days. But in the last 3 weeks, we've seen some significant changes with visa status that we need to be aware of. So the Biden administration withdrew the Trump administration rule requiring that schools that participate in SUVIS disclose Confucius Institutes and requiring that they register for foreign missions. So for those of us with Confucius Institutes, where those have been besieged now for some time, there's a reprieve for that. In addition, the Department of State, so, one, we have a withdrawn executive order, and then we have a Department of State announcement that announced that foreign students that hold F1 and M1 visas, student visas, will be granted exemptions regarding current COVID travel restrictions, specifically if you're coming out of Europe, the UK, and Brazil and others. And the student visa holders for these areas will not need to apply separately for individualized exemptions. So really taking away some of those for our international student services group, some of those really confusing barriers, and hopefully being able to support more international students, which we know is imperative for a graduate education. And then finally, and I think I'm most excited about this, right, that Homeland Security announced that it would be delaying the H-1B lottery system that would have dealt with applicants' earnings. Now, we knew, right, that there was a nationwide injunction on this through the Chamber of Commerce versus Department of Homeland Security that was issued in December. Nevertheless, it's always good to know that our Homeland Security is going to do what the court requires and really make that explicit. And then there's current advocacy. So advocacy by the Biden administration in many areas, which includes making clear that our OPT is going to stay in place. An issue that we've all seen problems with, ensuring that our Homeland Security officials at ports of entry know the guidance for international students and do not require more documentation than what is required. And we have all, fielded those types of really desperate phone calls from our students about that. And so any amount of really coordinating of efficiency that they could have would be fantastic. So I think that's all great news. In transitioning to foreign gifts and contract reporting, boy, this is fascinating, y'all. Since 1965, all colleges and universities through the Higher Education Act have been required to report at least twice a year all foreign gifts and contracts that you receive that are worth $250,000 or more, all told. And and how they define gifts and contracts is so broad, frankly, that most institutions are going to have something to report. The Department of Education released, I would call it a scathing report in October of last year that outlined all sorts of significant concerns that colleges and universities were not issuing these reports. And they have actively targeted a number of colleges and universities for investigations into this specific area. And in this report, the Department of Education articulated their concerns, and I have the quote on the screen here, that countries, and they were mainly focusing on Russia, China, Saudi Arabia, United Arab Emirates, Iran, that these countries are targeting institutions with, quote, investments, which we would call contracts, in order to project, quote, soft power, steal sensitive and proprietary research, and spread propaganda. Department of Education continues to be concerned about this, and we have seen no movement, no revocation of guidance, no revocation of the October report. It is still standing. And interestingly, so footnotes matter to lawyers, footnotes matter to me. On page 33, footnote 4, in this report, the Department of Education says, hey, we think that you should have a planned activity that your independent auditors, your outside auditors for your institution, need to audit these foreign gifts and contracts and add this to future audits. We have not seen a a centralized audit or single audit plan coming out of Department of Education that includes this yet. However, from the folks I talked to in DC, we do not see a change in this foreign gifts and contracts reporting requirements. We think that this will continue. And although we're seeing a lot of movement in other areas regarding international affairs, that the foreign gifts and contract reporting will continue. We're coming to the final stretch, to our final conclusions, with some trend observations, like where are we going in the future, and some interesting litigation. So there are 4 relatively significant, maybe very significant, areas of First Amendment law in which courts, I think, they're going to set new precedent in 2021, and like they're all going to apply to higher education. And that is remarkable because we historically have not seen the Supreme Court take up a lot of First Amendment claims, but this is a new Supreme Court. And so here we are with a number of these claims. And so the first one I want to call to your attention is Meriwether versus Trustees of Shawnee State University. And so I have some notes here. I want to make sure I get this right. So in Meriwether, a professor of political science and philosophy alleges that he received a written warning in violation of his First Amendment rights after he struggled in class to interact with a transgender student who asked him to address her in class by her appropriate gender pronoun. The faculty argues that that his sincerely held religious beliefs precluded him from referring to the student as she or her preferred pronouns. And the university enforced the applicable non-discrimination policy against the professor, taking the position that he had created a, quote, hostile environment in the class for the transgender student. The faculty argued his own free speech rights prevented the institution from disciplining him. The trial court rejected his claim and dismissed his complaint, reasoning that the gender pronouns by which he addressed his student in class constituted speech pursuant to his, quote, official duties for the institution and thus lacked First Amendment protection. On appeal in the Sixth Circuit Court of Appeals, the faculty has argued that the same rule applicable in California should be applicable in Ohio, and that, in fact, his speech was part of his scholarship and teaching. And so once the Sixth Circuit Court of Appeals issues this decision, we think it may be likely that the U.S. Supreme Court might take up this case as an opportunity to clarify the law in this area and to resolve issues of whether the rule is applicable in the Ninth Circuit is correct. And this, may persuade the court to take up this case to resolve the circuit courts. But this is interesting because for those of us, this is not the first time on our campuses that we have heard this set of factual circumstances. And so for those of us that deal in the harassment and discrimination area that are interested in social justice issues on our campus, this will be one to watch for sure this coming year. In addition, we're waiting to see if the U.S. Supreme Court takes up an appeal on a school district case, but it's a matter of first impression, and it will have long-ranging issues for community colleges that are also set up as school districts, but it will have a bleed-over effect for sure into higher education. In 2020, a student was frustrated with her inability to advance in cheerleading, posted a quite vulgar Snapchat dismissive of schools and cheer. The Third Circuit found that the post, which was created off campus on a Saturday, could not be a matter of constitutional law exposing the student to discipline. So the school district lost the case at the appellate level and has asked the Supreme Court to review because they argue that the ruling in the Third Circuit is way too extreme, that institutions should have the ability to interact with off-campus speech. Anyone in your student conduct area will be fascinated by this because whether or not institutions can reach into that off-campus speech, particularly online, this was Snapchat, but it would work for Insta or Twitter or whatever, right? We need to have a better understanding of that. Also, free speech codes on college and university campuses. The U.S. Supreme Court has taken up a difficult to pronounce case from Georgia in the 11th Circuit Court of Appeals, and it will redress whether or not students continue to have standing to challenge speech areas on campus. So, as a litigation strategy, many institutions of higher education, once they pull one of these claims, simply rewrite their policies and say, see, now it's moot, right? The case is moot. And can you continue? The question before the court will be, can you continue to have standing even if the institution has changed their policy to moot the case? Again, a fascinating area. Those that deal with your First Amendment free speech areas, your individuals who deal with your policies will be watching this with bated breath to see what is decided. And then finally, Trump versus Knight Institute. And the Second Circuit Court of Appeals held that President Trump, while he was president, violated the First Amendment by blocking his critics from access to Twitter back when he had a Twitter account. And the court found that the public comment part of his account was actually a public forum in cyberspace because he was a public official, to which the First Amendment applied. The president has filed a writ of certiorari requesting that the Supreme Court look at this case. Who knows if the Supreme Court will take that up? We're waiting. But this could have some serious impacts on our official Twitter and other social media accounts, and for public institution executives, particularly presidents. And how much can you moderate those public comment forums? And so this will have significant impact also in higher education. And in conclusion, I thank you, KU. Goldman versus the University of Kansas. In this, if you are thinking about reviewing or revising your academic integrity policy in the future, I would encourage you to look at this case. The very basic facts are: we had a graduate student who fabricated lab data, and they went through the academic integrity process. He was removed from the program in 2009. Now, we all know the wheels of justice turn slowly. This case was decided in 2020, the appeal. So this has been going on for like 11 years. He sued on some state claims and some federal claims. The federal claims are the parts that, are really interesting here, and because it was tortious interference, which is a state claim. Due process, right? Your academic integrity process, he alleged, did not fully provide him with full due process, and breach of contract. He tried to argue that his appointment letter as a grad student was actually a contract. And KU prevailed on all the claims. And the court went to great and extensive lengths to explain exactly why that letter of appointment was not a contract, and why the extensive amount of process in the academic integrity process was absolutely constitutional. So if you want to bounce your policy up against a set of facts and see kind of what that looks like, this is a great one to use. Goldman versus University of Kansas, and it's very contemporary, just came out a few months ago. So with that in conclusion, I appreciate so much your time today. I wish I could see you all. Hopefully 2022 will afford us that opportunity, and I'm going to stop sharing and take any questions that you have.
Mackenzie, thank you so much. Wow, that was so much information, and it's so much great information and great topics. So we've got about 10 minutes left, and so I will now identify clearly the one question that everyone has, right, which is absolutely impossible. But one of the things that's so interesting when we hear your presentations too, is you can see some of the chat, right? We want to argue with the agencies that issued the regulations, and so we want you to take that up. So, for the professional licensure piece, this wait a minute, you need to go, right? So, obviously, that's not your job, but I tell you, could you comment a little bit on where you see this going? Because as some of the colleagues pointed out, with the professional licensure disclosure, we can understand the context of, you know what, when a student is enrolled in an online program, it would be good not to falsely advertise that your academic program gets them their state licensure. I get that. But students that move in the middle of their program, that can impact then the disclosure. States often change their disclosures. And I get, hey, universities need to keep up, and I get that. Where do you think we're going? Because it fits in where is the university responsible? And where are these adults who are enrolling in graduate programs responsible to make sure that their program meets licensing requirements? Like, this fits a broader question, right? To what extent is the institution responsible? To what extent is the adult student responsible? I was wondering if you could comment on that.
Oh boy. So I have had these conversations with academic affairs professionals throughout the country because it was, well, it's been startling when we recognized that this was not just about, our online programs. This is about all of our programs. And we just kept, it was, I don't know, infuriating, frustrating, the horrible sinking recognition of the exact amount of time this was all going to take, and really, I don't know, the infantilizing. I mean, come on, you're adults, and I understand that frustration. What I know as a practical matter, what many institutions did is, at least they started with their chart. I don't know, except for their state at which they said yes, right? And maybe some of them called the adjoining states, or some of them did some research on where do you get most of your students from in that area, and call around to those states. Many professional organizations, particularly in allied health, were like, oh my, stop calling, because it's like every institution calling this, one little office in a state capital. Then they were like, what is going on? And so what many institutions have done, just practically, is they checked a whole bunch of I don't knows. Like, they purposely did not go out and ask the question, and checked a whole bunch of I don't knows. And then whenever they see a person with that out-of-state address, then they figure out that one, right? And they do them one or two at a time, or three or at a time, and figure out what is that. Now, that works if you have something less than a humongous out-of-state population. If you already had a large out-of-state population, it became administratively onerous. Those distance education rules. And there have been discussions about revocation or redesign of the distance education rules. However, those distance education rules are created not by the regular regulatory process, but because they deal with financial aid, they're what's called a negotiated rulemaking process, which is different. And with a negotiated rulemaking process, you have to go back into those, designate the negotiators, go back into the negotiation to make the rule changes, which is why these have been pending literally since the first era of Obama, because they are so daggum complicated. And I hope that the Biden administration sees the complication and chooses to go down that road of more negotiated rulemaking. And I think a precipitating factor could be those were written in a different era, where distance education was not like the norm for all of us for an extended period of time. And I think that's the hook, that when we talk with and when I talk with, my federal lobbyists and in our organizations, that's what I'm saying is, yeah, what we really want is to deal with the details. We got to get them back to the table. How do we get them back to that table? And I think it's through the larger issue of we've all been doing distance education, and that really was for many of us due to circumstances outside of our control. I also will be interested to see what type of enforcement actions financial aid will take whenever FSA comes to do reviews of institutions, and the professional licensure is now part of that analysis. We've not seen that yet, right? There's rules, but if the enforcement action is, please correct the following, okay, right? What are the damages? And we always kind of argue about that, right? Well, there's the rule, but what are the damages? And so if we see, and that's another way the Biden administration can address this, is to advise FSA during this 4-year period of a new initiation of this rule to have a consulting manner, as opposed to a more of a punitive manner.
Yeah.
We've seen that before with the VAWA implementation, right? With the Clery Act. People are not getting written up through FSA reviews on Clery. They're getting written up because their annual security reports are inaccurate, not because when financial aid looks at that regulatory side. They've done it before. I think that they should use that mechanism again.
Okay, thank you very much. You've touched on a lot of different things. That, boy, I tell you, you used the phrase regulatory whiplash earlier, and that was very noted by everyone listening to your presentation. How do you counsel your campuses to manage that whiplash? Because again, with the Dear Colleague letter, there was so much good. We felt there was so much good in that. But then a lot of student affairs professionals in mine was like, yes, it's good, but how on earth do we lift, all the things that are required, X, Y, Z, and all that. And then, of course, you had the whiplash with the Trump administration policies. Anyway, so how do you counsel your campuses to manage that whiplash?
So, I wish I was better at it. It is the ultimate challenge. And Title IX is a really great example. What we know from the Association of Title IX Administrators is the average span in a role of a Title IX coordinator is less than 3 years. And so I would argue that perhaps nationwide, we have not figured out that answer because it becomes an exhausting endeavor for which people don't stay. And so for those of us who have worked, you're hard pressed to find someone who even remembers the Dear Colleague letter these days, well along the 2007 guidance that I regulated under. Like, who even knew that? And so I think part of my attempt is to encourage people to take the long view, right? That unfortunately it's the journey, right? And that we've got to take the really long view on these issues, and that we take the approach, and we've tried this in Oklahoma. We all got together over the summer because we had no budget and travel issues. And we had a 4-part online live webinar series for the whole state that every institution participated in for these new regulations. And we got our heads together, and we're a state that can do that. We're just not that big. And all of us, in this area, we talk a lot. And we all got together and decided, okay, here's how we're going to approach this. So at least for our students, there's consistency across institutions. And that is a relational decision. We made that based upon our relationships with each other because we were trying to keep our students in mind at the beginning of how is it that we can make this the least complicated for our students. And so that meant doing interesting things like, when we changed training for employees, not making it overly complicated, utilizing that due process, but we all went out for a statewide RFP for decision makers. So we would all have the same pool of decision makers. And so we tried to be pretty innovative, but we were all thinking, wow, this is exhausting. We have got to take the long view of these rules. And then also recognizing, and I've had this discussion just yesterday, right? Under Obama, we had 8 years. And so there was some consistency. And when we see this really unique circumstance of new administration after only 4, right, which always creates a lot of regulatory chaos, and we see a change with the Senate, and we see really big changes. It is going to be a regulatory uphill road, and we're gonna just keep walking. And so I feel like the council part of general counsel, that's the part that I do more these days. Of we can do it. Woo, and please don't get exhausted. I am acknowledging really that it is discomforting, because we all have. I fully believe we want to do the right thing.
Sure.
Right? Whatever that is, whatever we're told that is sometimes, even if it's not the decisions we would choose. And so with empathy, we proceed.
Thank you, Mackenzie. We are at our appointed time, but I would like, if you could give just one more minute and a half. Peter Harris from NC State University asked a question that it's a good question, right on point. And if you don't mind, if we could just do one more minute, we'll carry this over a little bit, and then we'll all get our break necessary for the 3MT finals. Peter asks, you discussed transfer courses and the move away from regional accreditations. Does this also hold for prior degrees as well? Because many of us require degrees, especially bachelor's, from regionally accredited institutions.
The regulations say credits. The regulations do not say degrees. And you are definitely, I forget the 58,580. You want to look at the page number of the regulations, because it's literally 4 lines long, and it says the word credit. It does not say the word degree. And I haven't looked to see if they define the term credit as, could include degree. I doubt it. But there's some incredibly interesting commentary there about the rationale behind this, and some, I would say, you're going to want to read the language, because in the opinion of the previous Department of Education, there was 0 difference between institutions that were nationally accredited versus regional. 0, which I don't know if in higher ed we've not had that opinion, or else we would not be making transfer decisions based upon it. We simply do not have that same judgment. And so but the term was credit. Term was not degree.
Great. Thank you so much. So with that, we'll bring this to a close. Boy, I speak for everyone. Thank you so much yet again, Mackenzie, for making your time available to us.
Thank you.
And we really appreciate this presentation. It was so educational, so provocative, so many conversations. We could easily have 3 hours of breakout sessions that follow it. Which would lead to the bar probably at the end of the day would be most appropriate. But thank you so much for making time. With that, we're going to conclude our 3rd plenary of the conference. I will be turning off my camera and my microphone. And with that, the stage presentation will be over. Please move over to the sessions, where you will see the link at 5 minutes. You will see the link to the Zoom, which is necessary for the 3MT finals. And look forward to seeing you there. Mackenzie, many thanks.
Thank you.